My name is Cindy Wasser. I am first and foremost a mother, married to a man, who had to have her children conceived with the assistance of ovum donor and gestational carriers. Secondly, I am a lawyer. I spent 20 years of my life devoted to the criminal justice system, and then I became a fertility lawyer because the system failed me. The story of my surrogacy is one, of my first journey, is one that actually has become well known in the community and published in Toronto Life magazine. But at the time that I endured it, it was a very private story. I wish to say, before I really get into my submissions, that it is a great honor for me, as someone who is so devoted to the law, to appear before this honorable committee. And I wish to say that I support Bill 28 and its laudable intent to assist intended parents to achieve their dream of legal parenthood in both an affordable and accessible manner. I have noticed, however, several issues where the bill could benefit from clearer drafting. My written submissions that were sent in this morning will cover those, and I have also lent my name to the submissions and draft amendments that will be filed by others. I am also prepared to answer questions on those amendments. After suffering the pain of infertility and accepting that my only realistic pathway to motherhood included the donor and carrier, I was, as I said, deeply offended to learn that in order to become a mom legally, I needed judicial authority. While I was willing to challenge the legislation at that time, the result would likely have entailed a lengthy delay in obtaining parentage in a legal way, and not to mention with the added bonus of greater financial expense. At the point where my first daughter was born, my husband and I had already spent upwards of $80,000 for her creation. The legal expense for the declaration of parentage was going to cost us more than $6,000. My husband, who was a very private man and a saint, was not willing to be the test case, and so I respected his wishes, and we applied for the declaration. My experience changed my life tremendously. I vowed to help other parents become families through the use of surrogates and hoped that they would never have to go through what I did to become a mom. As a fertility lawyer who practices solely in the area of surrogacy, I have to say, however, that not one of my clients in the last 8 years, has been willing to take the time to challenge this law. I feel the need to publicly commend the grant applicants and the others who have spoken before you and their counsel for the courage which will benefit all families, not just those within the LGBTQ community. There are several issues that I do wish to address. One with respect to the issue of confidentiality in 17.3. I believe it may be inadvertent, but it is currently confusing as to whether it will apply to the streamlined process that is expected to occur. In my view, all documents filed by all intended parents and surrogates must be kept confidential, save and except for the issued birth certificate. I also fail to understand why there is a 7-day cooling off period before a surrogate can provide her consent to us. In my legal opinion, it is arbitrary and may not survive a challenge. I understand from where it comes in the adoption context, and so I think it may be worth considering a definition of surrogate that distinguishes between the woman who is known as a traditional surrogate and uses her own ova, and that of the gestational carrier who is not at all genetically connected to the child she carries. The cooling off period has no place in the situation where a gestational carrier who has no genetic attachment to the child has agreed to provide parental rights to the lawful parents and has undergone extensive medical, psychological, and legal counseling prior to the transfer. I also wish to address you on what I believe will be the submissions of some of my colleagues who do not share my full appreciation of this bill. You might hear from some that it is dangerous to dispense with full judicial oversight of the parentage process. But we can look to, as an example, the last several years in British Columbia, where a statutory declaration has dispensed with the need for judicial oversight in most situations. We have heard no evidence of abuse as a result. My colleagues may warn you of their anecdotal evidence of potential abuse with clients who might have lied about parenthood until they learned of the requirement for DNA and judicial oversight. I say, it matters not whether the heartbroken or culturally terrified parent is genetically related. Given that the birth registration is allowed in Ontario without regard to genetics, why must we humiliate that person further? An amendment, however, requiring a statutory declaration might be the compromise my colleagues and I can endorse. Some people may also come before you advocating for a system that continues to acknowledge that a carrier is a legal mother. Although those of us who needed these women to create our families are eternally grateful to them, it is far more than we should accept to refer to the carrier as the legal mother of our children. I, not the surrogate, became the real mother of my child from the moment I dreamed of her. Prior to the declaration, the birth, the transfer, prior to the creation of an embryo, to the ova retrieval, prior to the agreement of our ovum donors to assist us. It was from the moment I dreamed and planned with my soulmate to create my daughters. I deserved to be treated as any other woman who planned and dreamed to be a mother. I am a real mother. In the new scientific world that allows men only to be parents, this legal right should be extended equally to them and to all of the communities you have heard from today. In this wonderfully tolerant land we call Canada, it should be an automatic right to all who come here. Please do your part to make this a reality in Ontario, where you have the jurisdiction to do so. And thank you.
Thank you very much. We'll begin with the official opposition, starting with Mr. Hillier.
Thank you very much for being here and sharing your story today. You mentioned at the beginning of your comments about confidentiality, and this is something that I was wondering if you might be able to offer an opinion on or expand upon. I haven't seen it clearly in the legislation, but how about the release of information, medical history, under this legislation, with up to 4 parents being identified as parents, and it's not clear to me in the legislation that we see, you know, if it's how medical history, relevant medical history for in years to come that the child may need to find out. Is that addressed, or is it weak, or is it, or should we consider that aspect in more detail?
I think it's an excellent point, and thank you, Mr. Hillier, for raising it. As a fertility lawyer, I am always encouraging people who use the assistance of a donor to enter into a contract with that donor, not so much for the issue of determining parentage, but in order to have rights established between the parties for further disclosure of medical information. I was told I didn't need a contract when I began the donor process, even when my donor became known to me. I'm just lucky that she is an incredible woman, and I know she will contact me if, God forbid, she ever becomes ill. But my contracts with my clients and their donors state that there will be mutual disclosure of any genetic illness in the future, that there will be recognition that the child may one day want to know this person, and that he or she, the donor, will agree to meet that child. That may not be enforceable because you can't take someone kicking and screaming to Tim Hortons to meet the child they created.
Yeah.
But at least it gives them a chance to obtain independent legal advice as well before they understand what great gift they are giving and the long-term consequence of it.
But in your reading of the bill right now, is there any requirement or for genetic donors to provide any information that may be relevant, may be important in the health and the development of the child?
They provide a consent under the federal legislation when they attend at a clinic that says that and the consents themselves will usually allow for them to provide that information to the clinic eventually. But we're often talking about young women when we're talking about egg donors, especially, many of whom I noticed are around the age of 20, 21. I myself read those consents as the intended parent, and at that time really didn't contemplate what it meant. I have read stories of ovum donors who later created their own children and wondered about that half-sibling out there of their own child's. I wonder that for my own children. And so I think the requirement of legal advice that is required for the surrogacy arrangement in this bill is something to be contemplated for donors. Right now, the law does not require anywhere, at any level, that donors have legal advice.
Right. And therefore, no requirement to provide.
Nothing.
Unless
Nothing
it's
in law.
And if it is included in the donor agreement, that's still a civil
Precisely.
matter, which, in order to enforce, would require the deep pockets of going through the legal system to enforce.
Yeah, and I do tell all my clients in the surrogacy situation as well, the ability to enforce the contract is not practical. For one reason, the other side may not have the financial means to pay out even if you were to win. Right. Secondly, a lot of the things you might be asking them to enforce would be contrary to other legal issues.
If a decade, another generation from now, we'll be going back and looking at and we've seen this comes up these days about finding out medical history of adopted children, etc. And I'm wondering if we ought to be looking at some function within this legislation that mandates or compels medical history, relevant medical history.
As a mother, I applaud that. As a lawyer, I find that it is something I would encourage, because I find when I speak to my clients who are considering sometimes only ovum donation, they will carry their babies. The last thing they have even contemplated is future medical information of their child. They have spent more time looking at the physical characteristics of the donors on profile lists than thinking about the long-term health of the child they created. I may be a rare person that did care about that, and so I chose to make my donor known to me and a part of my children's life to some extent. She's not a mother, she's not a parent, but I know I can count on her for that information.
Right. Thank you.
Thank you very much, Ms. Wasser. Thank you very much, Mr. Hillier. That completes that round. We move now to Ms. DeNova for the NDP.
Yes, thank you. Thank you very much, Cindy, for your testimony. Thank you for bringing a new point of view, which is that of the heterosexual and the interest served to straight couples by this bill as well. And I think that's important to note that this also helps straight couples. You signed on to support Bill 28 with the potential amendments here,
yes.
And thank you for that as well. I'm wondering if you could just talk about maybe a couple of those amendments that you think are important while we've got some time.
Well, the ones that I would like to see that are that I have delivered myself relate to, as I said earlier, the definition of the surrogate. Right. With respect to the need to have independent legal advice prior to entering into the contract, there may also be what I think is an unintended drafting that suggests it is only the surrogate herself who needs, along with the parents, to enter into this contract. In the situation where the surrogate is in a committed relationship. It is most lawyers' views, those of us who practice in this field, that her partner needs to get legal advice and be a part of the contract. Perhaps not the consent if there is such a document later, but he must have or she must have independent legal advice along with the surrogate. They don't have to be separate. Mm-hmm. It's a very difficult process and they should be part of it together. The other thing I'd like to address is the Section 7 cooling off period, as I did earlier. It creates another conundrum if everyone remains in hospital. The current drafting says you will go to the surrogacy agreement and the parents, if it's in that agreement, which it almost always is, will have lawful authority as parents up into that 7-day period. Then it says any provision of the agreement respecting those rights after that period is of no effect. So in essence, the surrogate has day 7 only. And if she doesn't sign the consent on day 7 because she can't, for example, she's in hospital with complication, the surrogacy agreement giving the parents total lawful authority is of no value, and it becomes shared responsibility. A conundrum if the baby is also in the hospital for the hospital. They've been listening to the parents for 7 days, and now it's shared. And the surrogates, as you've heard, do not want that responsibility. So I also think we've also talked about some forms. There is one, significant one, that needs to be created for all hospitals in Ontario that is consistent about rights and responsibilities. Understanding, of course, the Morgentaler aspect of the fetus having no rights as a person until that moment of birth. But we can create a form. I am confident in our collective intelligent abilities that speaks to the child that will be born and the consent for the future to take place when that child has rights. And confidentiality of all documents, not just those under the court declaration, but all reference to surrogates should be kept sealed at Vital Statistics or in any other department where they might be filed. We haven't seen them, so it's hard for me to comment, but those are important. And then finally, I'd like to talk about the lack of enforceability of surrogacy agreements. I'm not sure why that section exists. I'm not sure why we wouldn't agree to enforce an agreement entered into with independent legal advice by all parties. It is a contract. Some terms we have to understand, such as selective reduction or termination of pregnancy, would never be enforceable, but they would otherwise be a breach of a contract remedied, if possible, by some other means. So I think they should be considered enforceable so that we give clarity to all those entering into that process. And they all want that clarity.
Thank you very much.
Thank you so much. We now move to the government. Recognize Mr. Broadnetti.
Thank you, Mr. Chair. And Ms. Bossa, thank you for your presentation today. I'm just going to follow up on the Section 10 part, the surrogacy part of the bill. So the bill makes several amendments that would protect the surrogate, but recognize that the surrogate as a parent when the baby is born, and basically recognize that the surrogate and the intended parents enter into a written agreement, surrogacy agreement before the child's conception. The surrogate and each intended parent receive independent legal advice, as you've touched upon already, before entering into the agreement. And the surrogate provide written consent to give up her parental status following the birth of the child in a cooling off period of 7 days, which you've talked about here as well, following the birth of the child, during which the surrogate cannot give up her parental status. So there are some safeguards provided. How important are these safeguards? And you commented already on perhaps some issues around that, the surrogacy stuff. So
Proper legal advice, which is difficult for you to legislate because the Law Society does not distinguish between what type of lawyer. It just says that we have an obligation not to go beyond our realm of experience. Those of us who practice in that area fear always that somebody's friend who's a real estate lawyer will draft the surrogacy contract. Right now, the clinics will demand, most of them, that a letter be obtained from the lawyer saying that proper advice was given, and my letters always say by fertility lawyers. That is an important thing. I think that legal advice for the surrogate spouse partner, if there is one, is critical. And I think that the rights and obligations of the intended parents must be defined right away, that there should not be a cooling off period. We deserve to be considered the parent right away, as soon as there is a legal child in existence.
As a lawyer myself, I've been here quite a while, but in politics for a long time. But I know that in the Law Society, there are specialists, certified specialists, various jurisdictions. Do you think that would make a difference if they seek advice from a certified specialist, or?
The certification process is a complicated one, and it also has certain limitations about at what point a lawyer can apply and what it means to be certified. It's also a costly one. Although I practiced criminal law for 20 years and was an extremely highly respected, high-profile criminal defense lawyer, I actually never applied for certification. I didn't see the point. So I don't think anyone questioned my skill in that field. I became a fertility lawyer and developed the skill quickly, partially because of my personal experience, but because I was capable.
Yes.
I don't think it's that. I think it's making sure that it's an area in which you practice and are fully aware of. The other day, somebody asked me if they could purchase an egg donor agreement from me, a lawyer, and I said, it's not that. It's not the money. I would never sell that. And I would give it if I knew that you were practicing in the field and would know what to do with it properly.
Yes.
And I think that is something that ethically all lawyers must deal with. And I want to believe, and I do believe, as all people are very good, that all lawyers are mostly very good and ethical. There will always be a problem, but we can address it by making sure that the bill itself says that all parties receive legal advice. You could draft it to say by lawyers or by counsel who practice in the field of fertility law, but that might be problematic, and it's something to consider.
Okay, thank you very much.
Thank you very much. That's all our time. Thank you, Ms. Wassa,
Thank
for
you so
your
much.
presentation. Thank you.